is that we haven't been presented with it yet, the judges haven't been presented with it, but I think that there is a movement to get universal people that would be streamlined and not just
Judge Guiney, I was going to kind of piggyback on what Kyle was talking about. The only thing, my only complaint is this, and I know that you guys do have something in place that's to make it so this, what I'm about to complain about, doesn't happen, but it's not happening. And I've noticed it in several of those courts that I've practiced in, is that when you go into the holdover, I mean, it's such like factory farming and cattle call. I mean, it's so loud and it's so, and there's just no dignity or confidence in that with your client when you're trying to make something happen. And I know that they're not supposed to bring the people up until, you know, their next time, the 9, 10, or 11, but it's something that is happening, and it just, I mean, there's just no dignity in it. And it's, I find that it's difficult for my clients to have any confidence in the process when they're back there with just that many people, and it's just that loud.
And I completely understand, and I think that you're right. I can see that absolutely, especially on big dockets, although I think that's just generally a problem across the board. And the reality is we are hamstrung by the poor design of our building. So if you come up with something, I am certainly all ears.
Another quick question, and I think I know the answer, but I'm just sort of wondering. You guys as judges, you really like learn the law, right? Because I mean, it's like the reason this is not pertaining because I don't think I've had a case in your court, but I've talked to a lot of prosecutors who are now defense lawyers, and the joke is they were much smarter as prosecutors because they got rulings in their favor by the judges. And so I guess one of my fears, and from everything I've heard about you, you're not a prosecutor on the bench. I mean, what could you suggest?
At the end of the day, we collectively as a body have to educate our friends and family members about the importance of voting all the way down the ballot from whoever that you choose. Because at the end of the day, there are a lot of my brethren who would be hard pressed to know how to case law research, may not be as abreast of the significant decisions as of late. And so all I can tell you for those people is to come prepared with the case law highlighted. For me, I found it to be humorous how off-putting, in a good way, it is when I can have a conversation or make inquiries on the record about what your argument is, how is that relative to the Green case, whatever. I real-time Westlaw is always up on my computer in trial. I am fairly confident that I know the law, but there are some areas of the law that I am more confident in. I am confident because I spent 2 years in child abuse with child abuse law and the area of that. I didn't ever do a stint in my major narcotics, major offenders. I'm less secure in my search and seizure rulings, which means I may take a little bit more time. If parties have come to me beforehand and said, Judge, we anticipate this to be an issue, obviously I'm not asking you to divulge your strategy, but if you know and it's clear because it's a conversation that you've had with the prosecutor, let me know that. Let the judges know that so they can at least start the process of mapping it out. Some of us map faster. I mean, certainly, and I don't think any of my brethren would suggest to you that they are 100% knowledgeable in every area of the law. That would be ludicrous. I try to keep up. I try to read the periodicals that come out from the Court of Appeals and CCA as they are released. I think that's true for more than you would anticipate of my brethren. But at the end of the day, come with your case law. I don't think I ever had a judge who didn't read what I presented.
I just wanted to express my support for your system as well. And in answer to what she was suggesting, as far as the noise and the holdovers, I think that's a bailiff issue. If we can get the bailiffs to help them shut up back there, it would make the job a lot better.
Quiet the defendants down as they're sitting. Is that what you mean?
Yes.
Okay.
It's in the misdemeanor courts and work with phones.
Let me get Yvonne, and then I will. Mr. Still, who just cut me off, say that I have to leave, but I'm gonna.
I was verifying she had an open door policy and is happy to answer anyone's questions who'd like to come by our chamber on and off docket day, I might add.
time. Oh God, don't talk to me about that. That is, okay, that is a conversation that I don't have the time to address.
Do the judges, are they aware how that system does not work?
Bob Scott, where's Bob? I saw him earlier.
No.
How
What do you
many
want me to
times I have
text
tried to
you or
log Bob
Twitter
Scott
you?
through e-filing from my computer on the bench. I am aware because I have tried it. I tried it in the early stages when I was doing defense work. Do I think that most of the judges are aware and are realistic? Other than just it sucks and nobody's happy? No. And so what I suggest that you all do, and I think HCCLA has kind of started the process of really spelling out all of the reasons that it is difficult. It's the visa payment, if you have, there are lots of issues. And so rather than just saying it sucks, it's miserable, we hate it, begin to enumerate them so at least we can have a countdown list of the things that we can address. The last thing I wanted to say really quickly before I forget is a practitioner tip. It's something that I actually, Judge Ritchie taught me before I took the bench, and it is to, you get amazed at how many judgments are wrong. And how many I have to send back to my clerk. I think that I probably catch most of them. But when you're at the clerk's table, swear under the paperwork with your client, most of the courts will have their judgments pre-done, waiting for a judge's signature. Most of the courts are now doing electronic thumbprints, like the misdemeanor courts. Give that a quick perusal to make sure that that affirmative finding that you negotiated away from your client isn't in fact on the judgment, or that that deadly weapon that you negotiated away for your client isn't on the judgment, that they are really getting a deferred as opposed to a straight probation, those sorts of things, because it is, at the other day the clerks are important. I got a lecture today on how I have done an illegal sentence, even though it was completely legal from what I had politely cited the statute number. But check your judgment, practitioner check. Yes, Craig's gonna cut me off. I'm gonna go back to work. I have a completely open door.
We're gonna take probably about 5 minutes so the next speaker can set up. Let me tell you this, some people didn't get an eval form for our speakers for today. The form is for only our speakers today. There's a box outside that you just drop this form off in as you leave. So if you need it, I have them, go talk to you. Take about 5 minutes, please.